If you've ever lived in a community with a homeowners association, you know the feeling, right? You follow all the rules, you pay your dues on time, but sometimes it just feels like the biggest decisions are happening behind closed doors. You start to wonder, what are they actually allowed to do? Well, it turns out a real-life court case gives us some pretty surprising answers. So let's get right to it. Here's the big question we're going to tackle. Can your HOA's committee, the one in charge of approving new decks or paint colors, can they really make those decisions over email without a formal meeting? And can they actually stop you from speaking up about something your neighbor wants to build? It's this classic battle between transparency and efficiency. And believe me, the answer is way more complex than you might think. To really get to the bottom of this, we're going to dive into the story of one homeowner who actually took her HOA to court over this exact thing. Her fight ended up clarifying a critical piece of law that affects millions of us. Okay, so let's set the scene. We're in Phoenix, Arizona, back in 2019. The case is Glover versus the Foothills Community Association. And the homeowner, a woman named Vicky Glover, argued that her HOA was violating the state's open meeting laws. I mean, these are the very rules designed to make sure homeowners have a say and a view into how their own community is run. Now, Miss Glover's complaint wasn't just a vague feeling that something was wrong. Nope, it was laser-focused. She challenged two very specific actions by the HOA's Design Review Committee, let's call it the DRC, that she was convinced were totally illegal. So here are the two big issues. First, she said the committee was conducting all its business, approving or denying homeowner requests through these secret email chains that happened between their official meetings. And second, when she actually showed up to the official meetings, she was told she wasn't allowed to speak about other homeowners' applications. And this, right here, is why this case matters so much, far beyond just Phoenix. What was really on trial was this fundamental idea, a homeowner's right to not just be in the room, but to be heard, and to actually see for themselves how the rules that govern their own property are being enforced. So to figure out who was right here, the judge had to go straight to the source, the law itself. In this case, it was a statute in Arizona that lays out exactly how HOAs are supposed to conduct their meetings. And you're going to see the entire case hinged on how you interpret just a few key phrases. At first glance, the law seems crystal clear, right? It says meetings are open and members shall be permitted to attend and speak at an appropriate time. It even has a policy statement saying it should be interpreted in favor of open meetings. So you'd think this is an open and shut case for the homeowner, right? Well, as is so often the case when you're talking about the law, the devil is totally in the details. The statute that seems to guarantee a homeowner's right to speak has this subtle but incredibly important distinction baked into it, a distinction that the entire outcome of this case would pivot on. Okay, listen closely because this is the key difference the whole case turned on. The law gives members a very specific right for meetings of the full board of directors. You get to speak on an item right before they vote on it. But for committee meetings, like the Design Review Committee in this case, the language is different. It just says members can speak at an appropriate time. That one little difference, it changes everything. So now we've got two different standards in the same law, one for the board and a vaguer one for its committees. So how did the judge actually rule on Miss Glover's two big complaints? All right, first up, the right to speak. The judge zoomed in on that phrase, appropriate time. The final ruling concluded that this specific language actually gives the power to the committee to decide what's appropriate. So when the committee decided it was not appropriate for Miss Glover to speak on another member's application, legally, they were within their rights. But what about all those email votes? This is where it gets really interesting. The judge looked at another key phrase, regularly scheduled. See, the open meeting law only applies to regularly scheduled committee meetings. The judge reasoned that email chains, by their very nature, aren't regularly scheduled, and therefore, and this is the kicker, they don't legally qualify as meetings that need to be open to members in the first place. And just like that, the final verdict was in. Based on a really strict, literal reading of the law's language, the judge denied Vicky Glover's petition. Legally speaking, the Foothills Community Association had not violated the open meeting law. I mean, what a surprising outcome, and one with huge implications. So this is way more than just a legal curiosity from Arizona. This ruling gives us some critical insights for anyone living in an HOA, whether you're a homeowner or serving on the board. So what should you take away from all this?
Okay, so let's break it down. It really all boils down to a few crucial lessons. First, the exact specific wording of a law matters so much more than its general spirit or intention. Second, the rules for your main HOA board can be way stricter than for its smaller committees, which might have a lot more power to control who speaks and when. And maybe the most shocking one of all, that whole flurry of emails between committee members deciding on your neighbor's new deck, legally that might not even be considered a meeting at all.
So if you remember just one thing, let it be this. Your common sense definition of a meeting, a bunch of people discussing and deciding things, is not necessarily the legal definition. If it's not regularly scheduled, the open meeting laws and all the rights they give you might not even apply. And that leaves us with one last, really big question to chew on. Does a law written this way ultimately protect an HOA's ability to operate efficiently? Letting committees handle small stuff quickly. Or does it create a giant loophole that undermines the very transparency homeowners expect and frankly deserve? It's a fundamental tension, and the answer probably depends on which side of the property line you're standing on.